Welcome, everybody. Thank you for being here for our September Ask the Organizer virtual event. We're very excited to have Carey Haladay with us today to talk about getting organized to navigate divorce. So I'm going to introduce you to Carey, and then I'll hand it off from there. Please feel free to ask questions as we go. You can either raise your real hand, your electronic hand, or you can type a question in the chat and we'll relay it to Carey. So Carey is a divorce consultant. Carey practiced exclusively in the area of family law from 2006 to 2014, after which she owned and operated a small business in Lake Oswego with her sisters. Carey returned to divorce practice in 2023. Her practice is focused on advising clients at critical relationship decision points, which she'll talk more about shortly. Carey loves all things Pacific Northwest, including rain. Good day for you today, Carey. Coffee and wine. After obtaining her undergraduate degree from DePauw University in Indiana, Carey came back to Oregon to attend law school at University of Oregon. Carey is an active member of the Oregon State Bar. Thank you so much for being with us today, Carey. I'll let you take it away. And I know you were going to give a disclaimer, I think, right off the bat.
Yeah, thank you. Hello, everyone. Thank you for having me here. I'm just really honored to be here and to be speaking with you guys about my practice area. As Whitney said, I meet with clients at critical relationship points. So for the most part, my clients are either contemplating leaving their marriage or anticipating that their marriage is ending. So, there's that kind of frantic, uncertain, crazy time where you're like, what do I do? Do I move out? Do I not move out? Do I, take all of the money out of the bank accounts? Am I supposed to be hoarding time with the kids? Like, what do I do? And that's when I meet with clients. I do some of my work is education that I explain kind of what the legal process looks like. And some of it is expectation settings. So what clients can expect when they, go through a divorce and what the outcomes look like in different areas. And then the last part I do is strategy. So talking about, when you do move out and what to do with your bank accounts and those sort of things. So I have a PowerPoint presentation. Jean, would you mind sharing it?
Sure.
Thank you.
And I think, Carey, so you are licensed in Oregon. So this presentation today is focused specifically on Oregon law.
Yes. So if we could go to the first, thank you. So if we could go to the first slide, I'm going to talk just a little bit about some legal disclaimers for today. The first one being that family law and divorce is a state law driven practice, meaning that my presentation is completely geared toward divorce in Oregon. It would be a different presentation and a different presenter for any divorces or that were happening in Washington and California. The biggest difference between states is how they deal with property. And we'll get into that a little bit later. But Oregon has their own whole system. They're not a community property state. They're not a separate property state. They have what's called an equitable distribution system. So that's the biggest thing. Just kind of at the outset, all of the information that I'm sharing with you all today is regarding divorce in Oregon. The other two things I just wanted to mention really quickly as we get started is that none of this should be considered legal, financial, or tax advice. All of the law is really fact-based and fact-specific. So the law doesn't change, but everybody's application and how it applies in their case can be vastly different. So I'm kind of talking in generalities today just to share information, but you should not take that as legal advice and, go move out of your house. The last thing I want to say is that there's no attorney-client privilege between you and me as the presenter today. So any questions you ask are not covered by attorney-client confidentiality. So that's just something to keep in mind. Okay, I think we're ready to get started. If you could go on to the first slide, Jean. Okay, so I thought what I'd do with you guys today is just kind of run through what I would typically do with a client that came in to see me. So this is the agenda that I use. The first thing I do is give the client an opportunity to talk about their relationship status and what issues they're having in their marriage. Oftentimes when clients come see me, it's the first time that they've sat down with a stranger, a professional, to talk about what's going on in their relationship. And that is kind of, it's intimidating to sit down and have to tell somebody that, you've had an affair, you think your spouse is having an affair, you're terribly unhappy, you want to leave, you're in financial trouble. All of those things are big things to come in and sit down and unload to a professional. So I kind of let people get started on their own. And then I ask follow-up questions like, when were you married? How long did you date before you were married? Did you live with your partner before you were married? Tell me about your kids. When were they born? What are they like? What are their activities? How much money do you make? How much money does your spouse make? What are their jobs? What do your assets look like? Do you have a house? Do you have a mortgage on that house? Retirement, investment accounts, stock options, kind of all these things. So as you're sitting here listening, you're probably like, wow, this is like a lot of like personal information that these people are sharing. And that's part of the process. It's one of the most challenging things that people find in a divorce process is you really kind of lay your whole life in front of the court and in front of your lawyers and in front of your spouse's lawyers with all the nitty gritty details. Oregon is a no-fault divorce state, which is like very much a buzzword right now because there's a whole bunch of states in the South that are looking to roll back their no-fault divorce laws. No-fault divorce just means the court does not care who caused the divorce or who wants to leave the marriage. So it's not relevant if someone's been having an affair. It's not relevant. Physical abuse, any kind of abuse is not relevant. If one party files a petition with the court and says, I do not want to be married anymore, the court will grant the divorce without any questions or anything related to why do you want the divorce, and things like that. Right now, it's interesting because in the news, if you're kind of following along all of the, political meanderings of what's going on, a lot of the southern states are looking at rolling back those no-fault divorce laws, which would then require the court to make a finding about whether parties could get divorced or not. So, for example, wife could go into the court and say, I want a divorce. Husband could object, and the court could say, wife, tell us about why you want a divorce. And then the court would make a ruling about whether a divorce would be granted or not. So it's a really interesting place to be in right now in family law, just because there's kind of all these things happening, and it's a lot like the reproductive freedoms things that we're dealing with. It's a much less publicized piece, but it is something that will drastically change how, people can operate in marriages if those laws change. And I think that those are being discussed in at least 10 states right now. So anyway, just like it's an interesting aside, but something that is happening, on a federal level. So after we go through relationship status and issues, I explain to people what the legal process looks like in Oregon. And Jean, if you could go to the next slide, I'll go kind of just, and the next one, sorry. And the next one. Thank you. Okay, so this is a little bit of what a timeline for what a divorce looks like if you file in the state of Oregon. It starts on the far left and kind of goes in this, tail around the end. So the first thing generally people do is retain a lawyer, and then one party files. In Oregon, there is no benefit to being the petitioner, who is the person that files, or the respondent, which is the person who's served. At the time of filing, one of the most important things I talk to clients about is a financial restraining order is put into place. And this is really intended to ensure that marital assets stay stagnant during the course of a proceeding. If you can imagine Someone filing and then all of a sudden changing insurance beneficiaries or selling a house or buying a car. These have major financial implications to what the marital estate looks like. So the court says, we just put a pause on everything. And the pause doesn't necessarily mean that you can't do any of those things. It means that you have to get an agreement from your spouse or a ruling from the court that that's okay during the pendency of the proceeding. Financial restraining order goes into place to the petitioner, so the person who files the divorce, on the date of filing, and it goes into place on the respondent on the day that they are served or accept service. Generally speaking, in divorce, there's not like a Perry Mason moment where the spouse is like, process server shows up at, the spouse's work and hands them an envelope of papers and says you've been served. That generally speaking doesn't happen. Most of the time, either lawyers are communicating and saying, hey, we filed, will you sign an acceptance of service? Or the parties are communicating and one of them says, I'll file and then you accept service. So it can be very amicable and low key, and most of the time it is, but there's always the cases that you do have to track people down. Next, the court retains jurisdiction to provide interim relief during the pendency of the proceeding. These are rulings that are only in place while the divorce is in process. So the court can rule on parenting time, child support, spousal support, exclusive use of real property, and that basically means who gets to stay in the marital home and have exclusive use of that property and who has to move out. Or if someone has already moved out, that they can't come back in, you don't have a key, you don't live there anymore. You still own the house, but you don't get to come in and out kind of as you wish. And the last thing they retain jurisdiction over is suit money. So ensuring that both parties have equal capacity to fund the divorce proceeding. Next in the process is an exchange of discovery. So discovery is statute driven and it is an extensive process in Oregon. I think that there's probably no fewer than 30 things on the list that you are required to exchange with your spouse. And it includes tax returns, it includes bank statements, retirement statements, insurance documents, stock options, and the court asked for 3 years of tax returns and 2 years of all your bank statements and debt statements. Ooh, sorry, the light just went off in my office because it doesn't think I'm here anymore. So the parties exchange that information. At this point, it's almost all electronic. So, there's like a share file that lawyers dump documents into. And so the idea is that everybody then is working off the same information. So what the point of doing this is you're trying to come up with a spreadsheet that has all of the marital assets and all of the marital debts. So then attorneys and the court can start kind of allocating those assets in the division process. So the discovery process really just allows everybody to get on the same page using the same statements. And certainly in a lot of marriages, both parties do not have access to all of that financial information. I meet with a lot of clients who, have no idea if they have an investment account and they know that they have a retirement account, but they don't know if their spouse has a retirement account. So the discovery process really allows everybody to get on the same page. Part of that discovery process is appraisals. And that includes real property, so residential appraisals, business appraisals, personal property, artwork, jewelry. And then I also put custody evaluation in the same bucket, even though it's not an appraisal. It is an analysis piece that the court uses if there is a dispute about custody. So that's also done as part of the discovery process. Next on the list is depositions. Attorneys have an opportunity to ask both parties questions about, and usually they get the discovery and then they might have questions about like, this is an interesting tax year for your business. Can you talk to me more about what happened? So you fill out all of the information that you receive in discovery during deposition. Next is negotiation. Most divorces are settled during the negotiation process. Wife's lawyer writes a letter and says, here's all the stuff and here's how we propose we deal with it. And husband's lawyer gets it and says, that's fine, that's fine, that's fine, that's not fine. And then they go back and forth. Most divorces are settled that way. Many divorces, however, go on to mediation, which is where a third party comes in and meets with both parties and both lawyers and tries to kind of hammer out a solution. Most divorces are settled prior to trial, but there are a percentage of them that go to trial, and that's exactly what you think it is. All the parties sit in a room with the judge, and the judge makes an ultimate adjudication about all issues in the divorce, makes a ruling. Oregon divorces are final on the day that the circuit court signs the judgment. So if you reach an agreement, it's called a stipulated judgment, and both parties sign in front of a notary, and then it goes to the judge, and the judge signs it. If it is done by trial or by arbitration, the parties don't sign it, and just the court or the arbitrator signs it. So that's kind of the whole process. If you went like from the very beginning to the very end in a traditional process, that is what it would look like. Thank you. All that said is that lots of people think that that sounds absolutely terrible. It can take, 18 months to 2 years to get a traditional divorce through an Oregon circuit court at this point. The circuit courts have been backed up for a long time, and COVID just almost put them over the edge. They deferred out a ton of hearings. It took them a long time to get Zoom capabilities up and start doing things remotely, which makes sense. I mean, it's like this huge thing to like all of a sudden just jump online with it was like a challenge. Anyway, they got incredibly behind. So now instead of taking like a year to 18 months, it's more like 18 months to 2.5 years to get a divorce through that process. And that is a really long time to be in that kind of tumultuous time. So out of that, there have been a lot of alternate processes that have kind of emerged. One of them, kind of like the least intrusive to the more intrusive, going from left to right, is document preparations. So 10 years ago, it was very rare that a lawyer would just draft documents for parties that reached an agreement. But now there's lots of people that do that. And of course, there's pluses and minuses to that. The positive thing is you're not spending a ton of money and a ton of time with lawyers trying to get your divorce complete. Instead, all negotiations are complete. The attorney is just a scrivener, and they're just drafting the documents and getting them filed with the court. They have varying billing practices. They're called, for the most part, unbundled services. So you just have to be really careful about what you're paying for and what you're getting, and to make sure that you're getting what you think you're getting. And the biggest problem with it is that you waive all protections, meaning the lawyers that are drafting these agreements are not checking it and saying, this is what you would get if you, saw lawyers or if you went to court. This is just like, I'm just doing you a favor in drafting your documents, and you're paying me for that. So there are benefits to that. The drawback is that you're not very well protected. Unbundled legal services, there are different ways to do this, but they can say, you have resolved all the financial issues in your case, but we're going to help you resolve just custody and parenting time issues. So anyway, there's things with that. And most of the time, those generally, again, there's little to no advocacy, and you waive certain protections. Collaborative law process has really emerged in the last 15 years. And this is a process by which both parties are represented by attorneys, but they commit not to go through a litigious process. Different collaborative lawyers do it differently, but the most probably standard procedure is that you schedule 4 meetings with your spouse and their lawyer and your lawyer, and you sit down at a big table and you try to hash out and reach agreements on kind of all issues in your case. It can be really great. It can also be really detrimental. If you talk to collaborative lawyers, they will say things like, we settle 98% of our cases using the collaborative process, and it's very warm and fuzzy and everybody loves it. And I know from speaking with people who have gone through that process that, a lot of people feel very pressured to reach an agreement. The biggest drawback in a collaborative law process is you sign an agreement that these lawyers will not represent you in a contested proceeding, meaning you can get 4 meetings in 8 months down the road. And if you don't sign any agreements, collaborative law lawyers are like, you got to go start fresh somewhere else. So the stakes are pretty high, and people feel pretty pressured. They think, I can't do this anymore. I don't want to be going through this process for another, 18 to 24 months. So they just settle. And again, like that's not true for everybody, but it is certainly a risk in the collaborative process. And I always advise people, if there's a significant bargaining inequity, that it is not a good place to end up in collaborative law divorce. So if there's physical or emotional abuse, if one party has kind of all the control over the finances, those are cases that are red flags that it's not a good fit for the collaborative law process. Okay, next slide. Okay, so the next thing I do with clients is I really just walk through kind of all the issues that they might face in their divorce. If you go to the next slide, Jean, we can talk about the first big one, which is child custody and related matters. So, the state, their policy is that they're trying just to make this the best, smoothest fit for the kids possible. If you go to the next slide, there are two different kinds of custody in Oregon. There's legal custody and physical custody. Legal custody is kind of, if you think about who's making the big decisions for your children, where are they going to school? Are they getting religious training? Can they get their ears pierced? Do they get a cell phone? Those kind of like big parenting decisions are considered legal custody. Parents can agree to joint legal custody, meaning that they continue to co-parent and make those decisions together. But in Oregon, if one parent says, I'm out, I don't want to be a joint legal custodian with this person, the court is required to award legal custody to one party or the other. So you can only agree to joint custody. And if you don't agree, if one party doesn't want to do it, then the court will adjudicate it. Physical custody is more what we think about in terms of custody, which is just where are the children spending time? Whose house do they live at? Where do they go on holidays? Who do they spend their birthday with? And these physical custody parenting plans are really hugely impactful. One of the interesting things in Oregon is that 10 years ago, the big focus just was on not disrupting kids' schedules. So, if you had a primary parent, the court spent a lot of time being like, okay, well, if mom has been a stay-at-home mom for these whole kids' life, then we want to keep the kids with mom during, the school week. So that ensures that the kids' schedule is least disrupted. They have really moved to a different strategy, in part because the court system took a survey of children of divorce who are my age, so now in their 30s and through 50s, and said, what do you wish we had done differently for you? What could we have done to make your life better as a child of divorce? And the overwhelming response was, I wish I had had more of an opportunity to have a good relationship with my non-custodial parent, meaning the parent who didn't have as much parenting time. So based on that, the court really moved to not a default 50-50. It's not a presumption, but the court, barring any crazy things that were happening, the court really said, okay, we're going to try to have kids spend pretty close to 50-50 time, because ultimately you can't sit your kid down and say, it's every other weekend, it's my weekend, you have to have quality time with me. That's not the way kids work, right? So the court said, ultimately, time is what time is, and time is important to spend with kids. So that's a really challenging pill to swallow for parents who have been primary custodians and have really made their life's work raising their kids. And I try really hard to be positive about it, and also add a dose of realism that, for the most part, divorcing parties are not stay-at-home spouses anymore. So they are going to have financial obligations and an obligation to support themselves that will require them to be less available for their kids. So more 50-50 parenting time does allow more time for parents to go out and work. Okay, next slide. These are the custody factors. Oregon law and all law really is based on two main things. So you have the statute, which the legislature decides, and then you have case law that interprets and fleshes that out. So these are the custody factors that the court looks like for both legal and physical custody, that, it looks at emotional ties between children, family members, interests of the parties, and attitude toward the child, desirability of continuing existing relationship, abuse of one party to the other, preference of the primary caretaker. And this is the one that they're really focused on that I was just talking about, the willingness and ability of each parent to facilitate and encourage a close and continuing relationship between the other parent and the child. So that is custody. And then we move on to the next slide, which is somewhat related, and that's child support. In Oregon, there's a child support calculator. There's a website that you go to. If you Google Oregon child support calculator, it will pop up a website, and you plug in mom's income, dad's income, cost of work-related childcare, cost of health insurance for the child, and parenting time, meaning if it's a 60-40 split or a 50-50 split, and then it spits out a child support obligation for one of the parents. And so that is not, they don't deviate from that. And I always have to let people know that, extracurricular activities for kids are massively expensive. I have one that plays club soccer, and every time I get the invoice, I almost die. But the point is that the court wouldn't care. They wouldn't require my husband to pay for those expenses. Parents can agree to pay for club soccer, but the court is not going to tell a parent, not a parent, say like you have to pay for that. So that's something to note, that kids are expensive, and child support probably isn't going to cover all of the things that you think it should cover, such as club soccer, or the one that I'm learning is really the zinger is the dance academies. Anyway, next slide, please. Okay, child attending school. So child attending school is a child between the ages of 18 and 21, and they are entitled to continue receiving support from their parents, assuming they meet the criteria of unmarried, making satisfactory academic progress, and taking a course load of over half time. Child support to a child attending school is paid directly to the child, not to the other parent. And another thing, court does not deal with college expenses. This is something that parents can agree to pay, but the court will not require parents to pay for college. If there is an agreement regarding payment for college expenses, a lot of time a child will sign a waiver saying that they waive this, the ability to receive $500 a month or whatever the child support calculation spits out for them. It also is important to note that if you have a child above the age of 18 who is entitled to receive child support, they are added as a party to the proceeding, and parents just really panic about that to see, the heading of your court case say mom v. dad v. child. It feels like yucky, but that is something that the court does. So next slide. Spousal support. Spousal support is, there's no formula calculated. This is one of the most challenging things in family law right now, is trying to set expectations regarding spousal support. Spousal support is an amount of money paid from a higher earning spouse to a lower earning spouse. And there are three elements. There's amount, duration, and termination. It just means how much are they paying? How long are they paying it? And once it's terminated, it's gone. Spousal support, child support, parenting time, and custody are all modifiable, but spousal support is not modifiable after it terminates. So once it terminates, it is over. If we could go to the next slide. And there are three types of spousal support: transitional support, maintenance support, and compensatory support. Transitional support is, generally speaking, a short duration support that's intended to help a party get their skills up or reaccredit or kind of transition back into the workforce. So if you think about the mom that we were just talking about that's been a primary stay-at-home spouse, she's let her nursing license lapse. It's going to take her 18 months to recertify, find a job as a nurse. That's what that transitional support is intended to do. Maintenance support is more of the just general, general support that's set for people to assist with lifestyle post-divorce. Compensatory support was very much a big thing back in kind of my parents' generation, and that was where you had, wife left grad school to support husband while he was in medical school, and then followed him around during his residency and his fellowship. And as a result, she ended up with no job skills. She dropped out of grad school, and now they're 30 years down the road, and he has this illustrious career as a surgeon, and she's not got a lot of job opportunities because she's been, she dropped everything to support his career, and compensatory support is intended to compensate her for that kind of sacrifice. Whitney, how are we doing time-wise? What time did you want me to wrap things up here?
So we're at about 4:30, so you're doing great. And does anybody
Okay.
have any questions for Carey so far? Okay, I don't see any hands yet. I have a ton of questions for you, which I can save till later, but um, please,
Okay, sounds
please
good.
keep going.
Okay, sounds good. Jean, can I go to my next slide? Okay, so these, again, much like the custody factors, these are kind of all the factors that the court looks at in awarding all of these support. Generally speaking, support lasts in a longer term marriage about half the length of the marriage. So if you if you have like a 20-year marriage, the non-earning spouse or the lower earning spouse can think that they would estimate around 10 years. 3 years and under, the court is generally not inclined to award spousal support. I think right now, in terms of trends, the court is awarding less spousal support than they were 20 years ago. And there is more of an expectation that the parties will get their own financial lives organized and sorted out, and everyone will be self-supporting. So certainly spousal support is still alive and well, but it is much less awarded and relied upon now than it was 20 years ago. Next slide, please, Jean. Okay, health insurance and related expenses. One parent will be ordered to provide healthcare coverage for the child. And again, that out-of-pocket expense will be calculated into the child support guidelines. Health insurance to former spouses. This can be a really big issue. So obviously there's COBRA continuation for larger employers. Smaller employers aren't covered under COBRA, but generally they have to have 9 months of continued coverage. Health insurance is super challenging right now. There's the exchange. It can be confusing. It can be really cost prohibitive. There's a lot of people right now that are engaging in quite a lot of mental health services post-pandemic. And so health insurance tends to be like a really hot topic and something that people are and should be concerned about. It takes a lot of planning. Fortunately, there are professionals that do just help people find health insurance. And so one of the things that I do is sorry, lights. One of the things I do is I match people up with professional referrals at the end of our meeting. And I have this really lovely woman who helps people figure out health insurance stuff. And she looks at, what their health insurance needs are and also what their budget is. And then she helps match people up with plans. So anyway, that's something that I talk with people about because this is one of those things that does require quite a bit of advanced planning. I think that we all know that 9 months post-divorce goes by pretty quickly. And if you don't have a plan, you don't want to end up without any coverage. So next slide, please. Life insurance, the court does require a payor spouse to maintain life insurance for both child support and spousal support. They determine the amount by basically figuring out what the lifetime of the support obligation is, and then they total it up, and that's the life insurance obligation. There are not generally step downs during the lifetime of the obligation. So if the court says that dad has to maintain a policy of $200,000 to secure spousal support, he will maintain that through the entire support obligation up until when he's 18, when the child is no longer eligible for support. So 18 or 21, if they fit the qualifications. And it doesn't step down. So if, the parent passes away on the child's eve of the 21st birthday, the child will receive the full benefit of the $200,000 life insurance policy, even though they might have only had one more support payment left. And the same thing goes with spousal support. Next slide, please. Tax considerations. This has been a huge changer in family law since 2017 under Tax Cuts and Job Acts of 2017. Spousal support is no longer considered to be income to the recipient spouse or deductible to the paying spouse. It's kind of been a little bit of a challenge for family law attorneys, in part because this is how we sold higher spousal support obligations to payors. There used to be, there was a benefit because the payor spouse would receive more of a tax benefit than the receiving spouse would get. So, you got a little bit of that, like federal government was helping fund the spousal support obligation, which was lovely. It's not there anymore. So that's changed kind of the how attorneys are able to sell and how the court is able to calculate support. And also, so it's like everything else in divorce, which is property division, debt allocation, all of those things. There are no tax consequences to any of that in a divorce. So you can divide life, you can divide insurance policies, you can divide retirement, and all of those things are not taxable events. Even though if you were to pull money out of your 401k or your IRA, normally there'd be tax consequences to that, but pursuant to federal rules, there is no tax consequence to any of that. Next slide, please. Okay, property division. So I touched on this just a little bit at the beginning of the presentation when I was talking about the fact that I'm only certified in the state of Oregon. Oregon does their own thing. They're not a community property state. They're not a separate property state. They are what's called an equitable distribution state. The analytical framework is set forth in a case. And if you could go to the next slide, Jean. This is how I usually talk about it with my clients. So the light blue circle is all the assets that you own in your marriage. It can be trusts that a party received prior to marriage. It's everything down to the pencil sitting on your desk is part of this marital property bucket. Marital assets are assets that are acquired during the marriage that are subject to the presumption of equal contribution and equal distribution. So the slate blue circle is what the court holds and says, we get to divide this however we want to, because this is considered marital assets. The marital property can include things like premarital property, gifts, and inheritances that are not subject to the presumption of equal contribution and therefore not subject to a equitable distribution under the court's purview. Example, because I think sometimes it's easier to talk in examples than it is to talk in like broad base. You have a husband and wife before the marriage receives a gift from her parents of $100,000. That parties get married, that money's in an account separate, it's over here. Parties get married, they buy a house, they have kids. 20 years down the road, this account just sits here and it grows because she hasn't been touching it. It's in her separate name only. And 20 years down the road, they decide they're going to get a divorce. That $100,000 account that's in her separate name only that they haven't touched and it's just grown through, regular, investment growth. That is her separate property. And the court says that's not part of the marital pot. Now, where it gets really complicated and kind of exciting from like a legal perspective is that $100,000 sits and it's in her separate name. Oh, but they want to buy a car, so they take $10,000 out of that account and they buy a minivan when their first baby is born. And then the account keeps going and it's still in her name. And then they decide they want to remodel their kitchen. So they go and they take $50,000 out of the account. So now the account's, $60,000. And the couple has kind of used it as like a piggy bank for their marriage. The husband would then make the claim like, well, that's marital property because we relied on that money. When we needed money, we used that account as a marital pot. We used it for our kids. We used it for our minivan that we drive the kids around in. We use it for the kitchen, which we needed to remodel. So that's kind of part of where these arguments start to get like a little bit, I think it's exciting and interesting, but it gets really, you start undermining these separate assets. And generally speaking, it happens a lot because this is the way people live their lives, right? Like you don't go through life when you're buying a minivan because you're expecting a baby. You're not thinking, well, but what happens if we get a divorce, 20 years down the road? And will I be sad that I took this money out, in 20 years? And so anyway, that is how property division works in Oregon. It is not clear. And it's a lot of analysis, and you can take every asset that is owned premaritally, you can take and do this whole analysis with it. It's called the Coons analysis. And there's, 3 steps that you walk through and questions that you ask and evidence that you present to the court that kind of goes all through that. So next slide, please. Okay, and that is kind of what divorce looks like in Oregon. The last thing, and I must have accidentally deleted the slide, but is debt allocation. The court divides debts just like they divide property. So for the most part, if it's a debt that's been accumulated during the marriage, the court will distribute that equitably, which more or less means 50-50, but equitably is equitably. So maybe not exactly 50-50. So I think that was it for my presentation. I would love to answer any questions you guys have about divorce in Oregon or my practice.
A lot of really great information. Thank you so much, Carey. So who has questions?
I have a question, which also thank you for sharing. I was curious, I've had some organizing clients who have a lot of like paperwork relating to divorces. So I was
Yes.
curious if you've noticed, like, are things moving kind of more paperless, or does it still just generate a lot of paper to keep?
I think it really depends on the client and the lawyer. I mean, certainly, young tech savvy clients are doing it all electronically because if you've seen, I mean, when I started practicing back in, the mid 2000s, we used to get bankers boxes full of documents and you would have to like treasure trove through them to get information. It was a nightmare. And now I think that it's that same banker's box. I think of like our conference room filled with these banker's boxes, but now instead it's on like a drive that or a
Mhm.
share drive that you're saying. So you're still able to sort through information. I certainly think that from an environmental perspective, I hope everybody's doing electronic discovery, but I also know that there's a reality that not all clients are able to get all that information in an electronic format that you can share and move around. So I think there's probably, at least for another 10 years or so, there's going to continue being this kind of parallel path of discovery models where you have to work with what your client can provide you. I certainly know that some of my old colleagues were saying that they have to pay to have, they get the banker's boxes and then they have to pay to have them basically converted to an electronic format so they can share them with opposing counsel because opposing counsel won't accept paper anymore. So, and that can be expensive. And so certainly I hope that answers your question. I think the short answer is some people do a lot of paper and hopefully they're moving more to it like electronic.
Makes sense. Thank you.
To piggyback off of Kayla's question and then maybe share an idea. So are divorce papers something that we need to have our clients keep indefinitely, Carrie? Like,
I do not think so. So once a divorce is final, the judgment is non-modifiable with respect to property division. Child support, spousal support, custody and parenting time are all modifiable as long as they're an issue that's modifiable, meaning like custody is not modifiable after a child turns 18. Right? But child support is modifiable until they turn 21, and spousal support may be modifiable as long as the lifetime of that support award goes. So that's modifiable, but you have to have a substantial change in circumstances to modify that. Meaning that in a divorce judgment, there's findings of fact that say, mother is awarded custody based on these 5 factors. And so then they have to show that something's different in those 5 factors, and that's why they need to go back and modify it. So the judgment, once it's final, is the new kind of holy grail of the marriage, and the discovery during the divorce doesn't matter anymore. The discovery, if they were to go and modify it, is something that would be all new and all fresh post-divorce. That said, one more caveat. The only time a court will go back in and tinker with a divorce judgment, the property division, is if there has been an undisclosed asset. So if one party can prove she hid an account, she didn't tell me about it, I had no idea it was there, it's not listed in the divorce judgment, it wasn't produced during discovery, the court can reopen the case and they get really angry for the most part, and the person who hid the account loses the whole thing. So maybe out of an overabundance of caution, they could keep it, but I used to never require clients to keep discovery. I used to tell them they could go shred it and be done with it because they wouldn't need it for a modification. That said, going through a protracted divorce, I always had a lot of confidence that we had all the information we needed and the case wouldn't be reopened.
thank you. And sometimes we're working oftentimes with clients who are overwhelmed, maybe due to a life experience that a situation they're going through, such as divorce, or it could be perhaps they have ADHD or another brain-based condition that makes it more challenging for executive functioning. So is something that we could do as organizers is possibly help folks get their ducks in a row so that they could come meet with you, because you said you have this kind of litany of questions for them, how much do you make? How much does your spouse make? All these different things. is that a way that we could help them get all that information together?
Absolutely. And I think that certainly, the organizer brain is a great brain to get divorced, right? Because you think of things in buckets, and divorce is all about buckets, meaning you have to have discovery in these areas and you fill your little file folders, be it with paper or with, electronically with files. And it can be a lot of yes, discovery and divorce is super challenging. Not just because it's a lot, but it's because you're dealing with people who are in these like kind of really traumatic places in their lives. People are not operating in their finest moment when they're going through a divorce. And you add a lot of upheaval because maybe they're moving out of the house, maybe they're losing time with their kids, maybe they're worried about how, what their finances are going to look like post-divorce. And so it's really challenging even without any neurodivergence. Then you add a lot of people with neurodivergence, and it like becomes kind of this sandwich that's really becomes impossible for people to bite off. So yes, I would say absolutely. Helping people just get the very basics of information about kind of what their life, their financial picture looks like is incredibly helpful.
Anyone else have a question for Carey?
I think I do. The modification, I'm Sharon,
Hi,
and the
Sharon.
modification can come in, let's say the higher earning partner that's probably paying the support for them, maybe doesn't have that high income they did at the end of the divorce, or maybe one of them has become seriously ill and needs more support. How can things like that be modified?
Yes, absolutely. So I was practicing in 2007, which I think we all remember as like a major financial crisis point. And I had represented a lot of real estate developers. So the real estate market, when it got turned upside down, these developers who had these huge, I mean, we're talking like $15,000 a month support obligations. All of a sudden, there was no way for them to pay it, right? So we encourage those clients to come back as soon as possible because the court can modify a support obligation back to the date the modification is filed, but not before. So you had some of these people who, again, were like not in a great period of their life because that housing crisis was really challenging for that demographic. And they, stuck their head in the sand, just didn't pay their support. And all that support ended up in arrears, meaning it had like this crazy compounding interest component. It was just stacking up. So yes, absolutely. That is where like a major change in income, or like you said, a major change in need. So, if a spouse that the court is anticipating is going to go out and, reactivate their nursing license, like the example I used before, but then, she's in a car accident and she is unable to work as a nurse. That's a modification. That's a grounds for modification for the court to come back and say, oh, well, we had thought she was going to go earn $80,000 a year working as a nurse, but that's not possible for her anymore. And then the court has to go through an analysis of what she is capable of earning, and then they recalculate support based on that.
So the court also would take into consideration that somebody has to be taking care of those children, whether it's a change in income or a change in physical ability to hold a job.
Yeah, well, and I think that really hits on one of the most challenging parts of the divorce is that you pull out one piece and all of a sudden another piece falls off on the other side. So it's
I
very
could
all
see that.
interconnected. And it certainly can be, there is not, generally speaking, easy divorces. I mean, financial circumstances drastically change. Couples that are separating lose economies of scale of living in the same house. Their kids lose the benefit of seeing both parents every day. And these are legitimately just realities of post-divorce life. So that's one of the things I talk to with people, not because I want to be a doomsdayer, but because I think that it's really important that people understand and have expectations of what that looks like. What does my post-divorce life look like? And it's different. It's different than when you were married, financially, emotionally, just day to day. It's a big difference.
You may not know that till you're in it.
Well,
Thank
and
you. Thank you
that's
very
one of
much.
the things. Yeah, of course. Well, that's one of the things I actually truly enjoy about my current practice is that, I can give people that snapshot and that preview of what it looks like. And I think a lot of my clients that I see don't actually end up pursuing a divorce. I think that sometimes they go back and they say, well, that's not really what I want. And maybe I'm not happy and maybe I'm going to work on something else to see if I can change that. And I think that I think that's perfectly legitimate.
Did anyone else have a question for Carey? Or a comment? Karen?
Yeah, I'm curious, maybe in a less like uh, logistical, legal way, but from you or anyone who maybe has experience with this, like what you would suggest. What do you think is the way that we can be most supportive if someone in our community, in our life, family, friends is in this place, like dealing with divorce? What's a good way to help with that?
Well, I mean, I think ultimately it's a little bit like when people go through any life transition, like when people have a baby, it's like the worst thing you can do is to go say, like, let me know I'm here if you need me. I mean, that's important too. But what you really need is to say, I'm available to you from 3 to 5 on Friday, and we can sit on your couch and I will just sit there while you cry, or I will take you out to dinner, or we can clean out your bedroom, or we can start getting your financial documents ready to give to your divorce lawyer. But I'm here for you from 3 to 5. I am yours, and we could spend that time however would most serve you in that moment. And I think that's, part of being, part of being a good friend in a time of like transition or a time of grief is to provide some really substantial and, actionable help.
I'm curious, Carrie. So something that we can also help people with here at Big Rocks is if they need to move. Like if one party, one member of the couple needs to move, or if they're selling the house and both need to move, and then we have kids involved too. I just want to let folks know that that's something that we can assist with, and that each spouse would have their own dedicated project manager, and we're not sharing any kind of confidential information between the two, and we understand that there are some gray areas that we need to be careful about, right?
Yes. And I think that's an incredible service that you provide. And I used to recommend to people who were using organizers or movers or doing it themselves to use the Post-it note method, which is very old-fashioned, but things that are really meaningful for you, you go through and you have a yellow Post-it note and your spouse has a green Post-it note. And so it just helps, direct people without putting the parties in a position that they're having to say, no, that's mine. No, that's theirs, kind of over and over again. Those big packets of Post-it notes can be incredibly helpful and really reduce stress, kind of in that moment and in that process.
And speaking of process, I'm curious about yours. So you are calling yourself a consultant. So does that mean you don't take people all the way through a trial if they need to? So you're kind of the person they meet with, and then you're getting them to all the different referrals and the people they need to talk to? Okay.
Yes. So generally speaking, I meet with clients for 2 hours. I go through a lot of what we just did, with a lot more specificity, based on what their personal circumstances are. And then I work with people on strategy in terms of, okay, well, what are your next steps? A lot of times the next steps are you need to kind of figure out what you're going to do with your life. Like if you've been a stay-at-home mom, like here's a vocational person that can help you find out what your passion is and figure out what you need to do to get an education, to get a job. I also match people up with divorce lawyers. So, kind of at the end of my meeting with them, I send them PowerPoint information. I send them professional referrals. I send them links to parenting plans. I send them lots of resources. And then a big chunk of that is professional referrals. Like, you should go meet with these 3 different attorneys and see who's a good fit for you. So I just meet with people for pretty much just 2 hours, and then I send a follow-up email. Lots of times I talk with people on the phone another time or two, because, it's like all things, when you get this much information, you're like, oh, you talk to your sister, and then you're like, I should have asked her that. So anyway, I have people just give me a call and we talk through questions. But no, I do not represent people in their divorce proceedings anymore. The only trial work I do at this point is I volunteer as a child advocate. So I represent kids in high conflict divorces as like a volunteer. So I do still make some court appearances and do some court filings just for that.
Thank you for your service with that. That's a very specific thing, and that's great that they have you because you're so knowledgeable. Wonderful. Does anyone have any last questions for Carey? Well, I have a million more, but I can ask you about them another time. We so appreciate you being here today and sharing all of your wisdom with us. Very grateful. And we'll send out your contact information afterwards to everyone who registered. Please, everybody, come back in October, on October 2nd from 4 to 5 p.m. We'll be talking about seasonal rhythms with Tiffany Hinton, and she's going to talk with us about how to create a plan for each season for ourselves. How do you set goals but honor the rhythm of the season, the rhythm of our bodies? So I think it'll be a really fascinating topic, and I look forward to exploring that with you. And in the chat, we have a message from Deb who says, thank you so much.
Oh, well, thank you everyone for having me. I just really, like you can tell, I just love this stuff. I think it's just interesting and fascinating, and I love working with clients, and I love sharing things. So if anybody has any questions afterwards, feel free to reach out.
We will. Thank you so much again, Carey. We appreciate you.
Okay, thank you.